Have you gone through the syllabus once?
Not yet.
Okay. So this will be a good start for any exam preparation. First, we have to look at the syllabus and see how many chapters are there, and try to understand what and all the concepts basically are compulsory for us to understand in this particular topic subject. So
Mm-hmm.
syllabus is recently last updated syllabus is November 2021. So there was not much change comparatively
Mm-hmm.
for like additional subjects or even NCA subject that we are seeing. All are like very recent updates. But
Mm-hmm.
property there is none. So that's good. Then regarding property, there are certain points that they are saying. There are total 11 major topics.
Mm-hmm.
So, this syllabus is designed to facilitate the study of the fundamental principles of the Canadian property law as the Canadian common law jurisdictions. The focus
Mm-hmm.
is on the real property. Core concepts are presented through the use of standard property law textbooks and property law Facebook. So, based on the prescribed material, we have to learn we have to learn these 11 topics. Okay. So, in
Mm-hmm.
these 11 topics, they are focusing on real properties. What do you mean by real? Do you know the difference between the real property and other forms of property?
Yeah, so the real properties are like you can see these are the lands
Mm-hmm.
and the buildings, and the other properties are like the movable properties. For example, car and jewelry. So these are the difference
Got
between
it.
the real and the personal properties.
Yes, exactly. So our exam subject is on real property. That means it's based on land related concepts only we are supposed to learn. However, in
Mm-hmm.
the first chapter, we do see a little bit of categories, and we understand what is what, but the focus is on the real property. Now, the syllabus has 11 major topics. First chapter that we are going to, study today is also of regarding property, its history and categories. What is the history? How did the property law came into picture in Canada?
Mm-hmm.
It came from the feudal system. It was derived from UK, and how it basically developed, and what are the different types and interpretations of what is a land, where
Mm-hmm.
and how much is what is a yeah. So what is a land, that what is a property that we are going to learn in first chapter. But in the
Mm-hmm.
second chapter, it is talking about boundaries. Boundaries is basically how much is the land, whether it is just your land, surface of the land, and what about underneath, what about above the land, there is airspace, how much airspace is also covered under your property. When you say your property, you have a piece of land, how much of that land is yours exactly, above the surface and below the surface. And what about water bodies, and is it only land where general that land we talk about, like with soil and stuff, or is it also covering whatever land is covered by water as well. So those things also, we have a lot of case laws to describe the boundaries, and I'd say this is one of the important concept, boundaries, because there could be question asked from the for the exam, because um, it's easy to frame a question on boundary, and we do need to understand the difference between the lateral boundaries and different forms of boundaries, and exactly how much is the land of that particular person we can recognize once we understand that chapter. And of course, in first chapter and second chapter, there are case laws that teaches us certain elements or tests that are involved All the syllabus case laws are very important in any NCA subjects. Of
Mhm.
course, even in property also, that's the same case. Now, coming to third chapter. Third chapter is about the concept of possession. Do you know
Mhm.
concept of possession?
No.
Idea? Hmm. Okay. So possession is basically about having the possession of the land, like your whether you are having the exclusive possession, continued
Mhm.
possession, are you excluding others from interfering with your possession of the land? See,
Mhm.
even in India as well, like we do talk about possessory possession rights more than the title, right? So there is a difference between the possession and the title. So possession,
Mhm.
is possession enough for the ownership, or is it not? And what and all types of positions are there? And on position also, there is a high chance of getting a question, especially position. Okay, chapter 3, you can mark it as important,
Okay.
mm, most important out of all. Okay,
Okay. Okay.
then we have common law estates. Common law estates also, considering different forms of estate. We can see here a little bit detailed they have mentioned in the chapter below. Yeah. So you can see estate concepts has there are two types of estates, that is fee simple and life estate. And what are these? Also, there is one more fee tail which is not currently existing. So fee simple and life estate. What is fee simple? What is life estate? We need to understand the difference between those two, meaning of those two,
Mhm.
and we need to be able to recognize. For example, if they give you a particular question, in that
Mhm.
we need to recognize whether it is a fee simple or life estate. So that in order to recognize such topics or such concepts in the question, and the type of the estate that a person has, that is catchy thing, especially in property. And it's doable. It felt when I first read property law, it did
Mhm.
feel like a little bit of way out of the line comparatively what we learn in other NCA subjects. You can see here it is more of history and different terms that we are not used to. It's quite theoretical subject, but
Okay.
it also needs to be learned also in that way. We can't treat it like any other NCA subjects because this is
Mhm.
way too different. And ISCA, like even the question answers that we are going to practice also are like
Mhm.
kind of different. They are theoretical questions.
Okay.
And you can see I have shared two sets of material, right? So today I
Mhm.
shared in the group two chapters, two
Mhm.
chapter notes, then two chapter question and answers, right?
Okay.
So
Okay.
the question and answers are covering the theory questions. So
Okay.
when I sat for the exam, I sat with these questions and answers, and they were helpful in a way that there was a form of ready-made essay with me on each topic. On each chapter, there was, ready-made essay, right? That helped
Okay.
me write in combination of two, three answers. I could write my exam question. So
Okay.
direct application was also there, and no matter how much we try, of course, there is going to be a new combination, permutation, and combination of a question that they are going to create. But
Mhm.
and when we are covering each and every corner of the syllabus, same thing happened with the foundations as well. We tried to cover every corner of the syllabus, even
Mhm.
though foundations, as you know, it's very lengthy topic, right? It has 25 articles, it has a lot of case
Mhm.
laws. We tried everything, questions, we prepared questions covering all the concepts. So the exam
Mhm.
was, easy yesterday because it covered, our question and answers covered most of it. And
Mhm.
it also gives you a particular very good practice. So that's our goal even here. For property, if we
Mhm.
first understand the subject matter, we are able to
Mhm.
differentiate the terms, and
Mhm.
then next is question and answer practice that we have to
Okay.
thoroughly understand. Then you are ready for the exam. I prepared for this exam in, as I said, it was like 10-11 days maximum.
Okay.
So yeah, so that was kind of a quick understanding. But first reading I had done before that. I
Mhm.
didn't understand anything before, like when I was doing first reading.
Okay.
Then I canceled my exam. So second time when I was preparing for this, I didn't have much time, but I had a plan. So I had a plan about how to prepare, and I followed that plan, made sure every corner of the syllabus is covered, which is very important for any exam. So then you get confidence. How whatever terminology you're seeing, you're able to understand that. Then you'll be able to understand the question properly. There will be
Okay.
fact pattern questions. Sometimes there will be essay questions as well. So both
Mhm.
of which we will try to practice.
Like similar to foundations, right?
Yeah, yeah, yeah. So
Okay.
once you have written all the NC exam, then it becomes, little bit comfortable to write for property law.
Mhm.
And even for me, after writing foundation, before writing foundation, I had actually registered for property, which,
Okay.
the preparation went horribly, because I
Oh.
was not understanding where to start from, where to, what to refer to, what not to refer to, and the materials that were available that time was also not so good. Um,
Mhm.
so I needed to, come up with whole different plan, and there was nobody giving, proper question and answers also, and these are theory
Mhm.
things. So I had to prepare them. Then regarding yeah, second time when I was preparing for property law, I
Mhm.
had a plan, like, because already I had gone through the foundations. So
Mhm.
foundations mein, uh, I came up with the speedy way of covering large content, and
Okay.
kind of got used to reading very fast. So that helped me to get through the property exam, and it was quite easy, I would say. Out of all my exams total, there are 6 subjects that I got, including
Mhm.
this one was extra. So out of all the exams I wrote this paper, I think still leaving some minutes. 3 hours is never enough, right? But for this exam, I felt like it was enough. And
Okay.
I had time to kind of, waste. And 100%
Mhm.
paper was also completed. Then I left, there was time left out of three
Oh.
hours. Yeah,
Okay.
so it's doable. So the concepts are very easy, but
Mhm.
it look little bit different because we're not used to talking like, with fee simple life estate and all in
Mm. Yeah.
real life. Yeah, day to day for practice, right? We use, like, modern terminologies for everything. And
Mhm.
even people who are practicing in Canada also wouldn't, use these things, because always we need to understand the theory concept that we are going to learn is always going to be, bit boring, bit historical understanding, and it is going to be little bit boring, but theoretical approach, right? But in the
Okay.
exam, we need to only or, like, write answers from what we have understood in the as per NCA syllabus only. And
Okay.
in real life, when you're practicing that time, it will be slightly different. But
Mhm.
your preparation of property law exam will also be helpful for your uh, you know bar exam if you're appearing for Ontario bar exam.
Okay.
So you have, real property also one concept, and estate planning. There are two topics basically on this. So
Okay.
that will be really helpful for you to, understand the concepts, and there will be a lot of time left for you to focus on other subjects as well, because there are nine subjects overall. PR, if you combine as one, then it'll be easy. And even the concept is very similar to what we learn for California bar exam. So, in
Mhm.
case if you have any plans about, like, having another qualification, California bar exam also people can write directly, right? So you don't have to have
Cali
California.
California. So can you
Yeah.
please elaborate on that? What is that? Because this is the first time I'm hearing about
Oh,
this thing.
okay. So people who want to practice in US, as yeah,
Okay.
international lawyers, so
Uh-huh.
they can appear for California bar. That is the only option available for outsiders, you could say, like how
Oh,
we write
okay.
MCA, but there is no like assessment application as separate, like long-term process is not there. Similar to,
Uh-huh.
even UK as well, like you can write the
But Vidya,
SQE exams.
Vidya,
Mm-hmm.
Yes,
with respect to California bar, I think we have to do the masters, right? Like we just can't. I think we can't just like apply for the California bar, right?
we can.
We
So
can.
that there is
I
we
see.
can. There is an exemption. So I spoke to a person who actually gave the exam recently, very recently. I had plans to do
Okay.
this way back. So I had researched about this. So I knew it is possible. But
Mm-hmm.
regarding the syllabus, I came to know recently because they thought I teach property law. So, the student actually contacted me. Then I came to know they're preparing for, bar exam for the second time. So, so he basically asked me about property law. For him, real property was he was finding it a bit difficult. So I told him, no, like I am not actually preparing for California bar exam right now. I did have plans, but I did not study it yet. So I can't teach you. But then he started talking about what is the syllabus topics. So fee simple, life estate, perpetuity, possession, all the concepts now that we are learning here, the same thing. So then after listening to that, then I was like, oh, I know these concepts. So for Canada also, it's the same concept. Whatever we are learning for our bar exam also, it will be helpful. And even later, especially people who are going to practice in Canada, and having, qualification in Canada, if you again write just one more exam of course, the exam is a bit ruthless, like very long hours, like 5 hours, 6 hours, like that. Their exam will be with breaks, of
Mm-hmm.
course. But that is doable. We will discuss on that if you are interested. Are you guys interested in California bar exam?
Yeah, yeah. The
Oh,
moment you told about me this, so मैं बड़ा ज्यादा ना cautious हो गया. मैंने कहा यार, like, is it like possible कि we are eligible for the California exam? So
yes, yes.
what is the
I
exact
am.
eligibility? What is the
I am in.
exact?
I'm sorry, guys, to interrupt, but I too am interested in California bar. But I would like to. I would like for us to first get through the property law topic, and then we can maybe discuss
Yes,
that. Simply because of
yes.
the fact that it's a long journey, like NCA. Then like first requalifying in Canada is a big hurdle, and maybe then
Yeah,
we can aim
true,
for that as well.
true. True, true. So after class, we will,
We can definitely stick around, and yep.
we will,
Yep.
yeah, we will discuss. So I will talk about the eligibility and exams, everything. Okay, so we will discuss that. So now, coming back to our NCA syllabus for property law. So we have topic five. Topic five is our favorite, Aboriginal property rights and land. So in any subject, if Aboriginal topic comes, उसका मतलब क्या है? That is important, and it's also interesting and easy to learn, right? Because by now, people who have written other exams like constitution, at least if you have studied constitution, then foundation, then this should be like, in an inner tip of tongue, like Delgamove case, Kilcotton case, Haida Nation case. You should know these cases by now. But
Mhm.
when we are dealing with this chapter, we are gonna, assume that as you don't know, because we have to cover everything. There might be student who is, not prepared for these subjects and want to learn about property law first, right? So I'm gonna assume that you don't know anything, and I'm gonna teach that cases as well. So we'll cover those. But it's very interesting and easy to learn this chapter as well. And the question, mm, yeah, question could come on this, but comparatively, as I said, I was telling chapter 3, position, topic of position, that is
Mhm.
still, still on the number one important topic. But later you can put, yeah, Aboriginal as the second most important, you can put there.
Okay.
Then chapter 6 is dealing with the origin and nature of equitable interest. So this concept has, we will understand a little bit of historical development of equity, and which has, court of chancery. What is court of chancery basically, how it developed, and equity and law, there is a difference, right? So equity is
Mhm.
more of like, morality and like kind of a discretionary power that the
Mhm.
court used to use. And so how this court of chancery used to use the equity in their judgments in the adjudication process, and how it has changed the common law over the time. So related to property, of course. So that is gonna, equity is a concept that applies to everything, even in admin, in criminal law, everything. But we are going to focus equity concept to property. Like how did the property rights were recognized in the court of chancery, and now what is the different. And there are some concepts like statute of uses. This is also important. You can mark it. We will understand that in detail. Then creating a modern trust in real property after the statute of uses. So statute of uses used to be there. So now, like, what is the modern way of creating a trust in real property? Not very important, but still, like a concept we will cover. The nature and modern equitable interests, express trust, resulting trust. These words are very important to terminology, understanding this terminology is very important. What is express trust? What is resulting trust? They may give you a scenario which could be like, actual incorporation of a resulting trust. You may have to recognize it and say it, specifically, हाँ, यहाँ पे, here in the instant case, the formation this person has prepared is of resulting trust. So like that. So that is the reason why, like, whatever concept like terminology is coming, you need to understand each and every meaning, and flag it also accordingly in your, notes material. So that we understand the difference between the terms. Then topic 7 is dealing with conditional transfers and future interests. So here we have the concept of, yeah, this is very, 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 very important. So this you can put right next to possession. Possession jitna hi important hai. This is equal importance as much as, possession concept. So rule against perpetuities. They will definitely ask you a, um, fact pattern question on rule against perpetuities, and what is rule against perpetuity, how it is going to be applicable, and yeah, how it is established, and how you are going to, apply it, that you are going to learn. It's basically, if I say in simple words, rule against perpetuity is that 21-year period. If anybody, demises, if anybody dies, basically, their property should become somebody else's property. So like somebody else should take over the title of that property within the 21 years. And of course, it does have, certain limitations, and who can have, who can't have. And there are, again, like underneath concepts like doctrine of further title, and fee simple, like there's some underlining concepts are there, which we will learn in the beginning, no, in the first chapter and all. Then we will understand it much better. Future interest, how to create, what are the types of future interest, what is vested and contingent interest. This you would remember from our Indian land law as well, land law concept as well. But this is again, like, new case laws will be there. You just have to learn new case laws and, learn its interpretation of this concept in Canada. So their perspective of that particular concept. What are determinable and conditional assets? So is it void? Is it voidable? Those things we have to, talk about. Invalidity. When a particular condition becomes invalid, that also we have to say. And wherever this transfers related comes, no, it could be, from direct transfer or through will also. So sometimes in the question, they might give you a will. Somebody has written a will, and portion of the will is as follows, and they are, vesting their properties, and that person dies. That's why the question has come up now, and they will ask like whether this is applicable. The year the will was written, the childrens were like, of course, the beneficiaries were like this much year old, this much year old kid or something. They might tell, and sometimes even the will people write no unborn child also, even if that person was not even pregnant at that time. It'll be like, huh, like it should, this particular property or like, account amount should go to my grandson. Of course, that time he didn't have a grandson. What about if currently he's having a granddaughter? Should it go to granddaughter or not? Or it should go to, entirely, it should, as per the succession laws, it should go, not even going to, successor, that he has chosen as per the will. So those are the, practical issues they will give you, which is easy to do when we have enough practice of such questions. Then topic 8 is leases and licenses. This chapter, question may come from this, of course, like, you can put it next to Aboriginal. That important, okay? Not very, very, very important, but important. You may get a commercial setting. They will explain like, okay, now how would the, lease and license would happen here? What under the clauses that needed to be present in this? Or if any clause is there, is it valid or not? Like that also question may come. This is quite easy to understand because, proper syllabus they have given. The question will be like within that only. And the topics within, like, this subtopics are uh, very what do you say, like within the boundaries, I would say. It's not like going out of the syllabus. Like we don't have to imagine a scenario for a question for this. So mostly it will be like a theory question from this chapter. And even if it comes as a small uh, fact based question, but it will be always, the answer will be always in a theory essay format. So the fundamental nature of lease, the nature of the landlord and the tenant's interest, all these are, theory topics. Termination and remedies, important here. Out of these, obligations in landlords and tenants, these also question had come. Then property status of licenses. Then we have residential tenancy reform, general principles. This also question had come. So these are all theory questions, okay, from chapter.
Mhm. Mhm.
Then we have chapter 9. This is again next to possession and the rule against perpetuity. You can put shared ownership over there. This is also important as those topics, because this is related to joint tenancy, tenancy in common, tenancy by entities, and co-personally. So basically, what and all types of, there are four forms of co-ownerships, and out of, like, basically there used to be four types, but currently what are there? Only two are there. That is the joint tenancy and the tenancy in common. And we have to identify, and maybe, we have to distinguish two types of tenancies, or and choose one basically, right? So we need to understand the terminology properly and be able to recognize which one is, currently asked in the exam. And or like, you might have to choose one as a solution for the problem. That also can be, chosen Then in that we learn one by one joint tenancies and what are the four unities under joint tenancies, what are required, and to prove there is joint tenancy. Then tenancy in common, what are the requirements for the and the nature of tenancy in common, what is the difference between them, elements, everything we are going to learn. Then severance of a joint tenancy. How exactly you can sever from a joint tenancy is very important. These are all practical issues. Also in life, it comes up like, okay, you have bought a property along with your friend. Okay, now you move to US. Okay, now you are planning to move to US, and you no longer need that particular property, or you just want to sell that property, but your joint tenant is the owner. That person doesn't want to sell the property. Then what happens? Do you have to like wait till that person dies and your property becomes yours? And does it by death of one of the co-owners, will the property become the other person's automatically, or do they have to write a will, and will it go to their legal heirs? So under which concept it is going to be covered, whether it is called as joint tenancy, whether it is called as joint tenant in common, in which which of these forms of tenancy is going to be death is going to be also a form of transfer of property or ownership. So those things will be asked in this particular chapter. So that's why this is important. इसके ऊपर भी questions आते हैं. Then the last but one topic, right? Yeah, last but one topic is servitude of over property. Servitude over property is basically what you can do, like kind of like interest that you can share with of the property. So like easement rights. Easementary rights we know, right? Like right to right of way on the
Yeah.
property, so that you can transfer just the interest. Then creation of easement. How does these easements are created? There are case laws that we can learn. Wilden case laws is also important. Then we have estoppel concept, important. Then scope, location, and termination of easement, basically. Then profits of Pandre. So we will be learning from case laws what is this concept, and how to identify that as well in the exam. Then covenants running with the property, restrictive covenants. Now you have leased your property, or like your basically you and your neighbor in property, basically such examples will come up, you and your neighbor, because the land is basically you can't take it and run like from that place, like you can move, the land will not move from there. So um what happens is like you and your neighbor is like kind of tied up together because of the land, and whatever you do on the property will also affect him, and whatever they do on the property will also affect you. You don't believe there are cases which is about the hedges, like bush, the tree bush and all, like whatever you have in your veranda or like border of your property, if the branch is like slightly on the side of the other person's property, the neighbor's property, they can file a case against you, not just like small complaint or something. They can file a case against you for hedges. Even there are cases where the person has filed a suit for cleaning their side of the like cutting their side of the wedges. They're like, no, you don't cut our side of the wedges. Like you keep your side of the wedges only, right? So there are like some silly cases as well. When we read, we will discuss and we'll have a good laugh as well. But of course, that way we'll remember the cases really well on the exam day. But yeah, such bizarre scenarios will come up. It's very interesting. Then we have the concept of, okay, so the importance of easement is also like average. Okay, not very, very, very important, but yeah, important anyway. Then the final topic is priorities and registration. This concept again, it's very topic specific, kind of like it's not going to be like mixed with other concepts. So this one and the lease topic, I felt individual question aega only on this chapter. It is not going to be like, RAP and the rule against perpetuity and the estates. So it's not going to be like together with the different chapter. Lease and chapter 11, this one is going to be like topic specific. And there may be some question from here, but not super important. But we will cover like how the registration needs to be done, the very brief understanding of title registration we will learn, and what are the advent of registrations, what are the types of deed registration systems, then yeah, priorities at common law and equities. What is priority? What is registration? Those things also we will learn. So this is like quick overview of entire syllabus for you, so that you have an idea that what is to come, or like what to expect out of your syllabus. Um, Overall, you have so much to cover, but you know, be assured that we are going to cover each and every part of the syllabus in the next 15 sessions. We are going to focus on covering the syllabus, and we will try to understand each and every terminology as is. And I need you to ask me questions if you're not able to understand any particular terminology or concepts. We will take time to um, learn the concepts first, and in the remaining 15 days, or like 10 days remaining for the exam after the syllabus, then we will do the question and answers practice. Any doubts so far regarding the syllabus overview and preparation method that we are planning?
No.
Okay. So let's begin with our first chapter. Okay. So first chapter, as I informed, it is history and categories of the property. So generally about property history, when you say, it talks about where did the law come from, property law come from, and how it has been developed so far, and currently what practice is going on. Then the categories of property, what sort of properties are there. Then yeah. So to begin with, Canadian property law has a deep historical roots, and it's influenced by various sources, including feudal structures, the reception of English law, and the overlay of English law on pre-existing Aboriginal property rights. Why do you think overlay of English law on pre-existing Aboriginal rights is there? Because you need to know the very beginning. How did Canada came into like what it is today? There was a European contact, right? European contact, or you can say the basic invasion of property happened, right? So it's all connected with the land. So there was the settlement happened, and they brought their laws, and kind of they also tried to recognize the rights of the Aboriginal people, and entered into treaties with them, kind of a compromise they did. Okay, but it always goes back to their Aboriginal property rights, because Aboriginal peoples are the original landowners of Canada, right? Entirely. First, they were there, and they were holding the property. They were pre-existing. There were already pre-existing property rights on that particular land, which currently is owned by then Crown, and then of course the private people are now having the property rights. Then we have to understand these terminology and these structures. Now, what is feudal structure? When we say feudal structure, this is a system of hierarchy. Okay, The feudal system was a hierarchical structure of land holding based on the relationship between the king and his subjects. So earlier, king is the rule of king used to be there, and king owned everything, right? King owned entire land, all the land, and he then what he used to do, he used to grant the land to his nobles. For what? So that the nobles, they are also called as tenants in chief. Tenants in chief means the person who becomes the tenant of the property first. Okay, tenants in chief. So, and he used to give the land to these nobles for two reasons. One, which is not written here. One, basically for the land to be used. Land ऐसा waste नहीं करना चाहिए. And land not to be wasted. That is also an underlying concept. Okay. But land was given for so that land is put to good use. They used to do agriculture, something they used to do, and it was of good use. Second, the most important for these people that time was support, right? Military service and other obligation that they could do towards the king. And these nobles, what they used to do, they were not using for themselves. They also had subtenants. So subtenants concept also came from here earlier in the feudal system structure, and these nobles in turn granted the portion of their land to vassals or subtenants under the similar conditions, creating a pyramid of land holding. You wouldn't believe, for this one to understand, I googled feudal structure pyramid, and I saw that particular pyramid. You will pyramid. So if you Google this, you will find a particular image. Yeah, I got it.
Can
I'll
you
just play.
can
Yeah,
you share that?
yeah. I'll just show you the screen.
Oh,
Oh, one second. Yeah. See, you
okay.
can see the exchange of services. King is to give the land
Mm-hmm.
to the nobles, and noble used to
Okay.
give the service basically, right?
Mm-hmm.
And
Right.
the nobles again gave the property to the vassals. Okay,
Mm-hmm.
they sublet this, and they used to give protection and military services to the nobles. And the knights again gave it to the land, and protection was given to peasants, that is normal people. They used to give food and services to king and vassals. So this is the feudal pyramid structure. We can download, I think. Yeah. So this is the feudal pyramid structure that we need to like kind of like have an imagination for just for imagination. Okay. Then that used to be the working of use of property, but the king owned all the land and he granted it to nobles. The word is granting, right? It's not a transfer, but of course, like he is giving off his property, but by way of what? Not sale, right? He is transferring, but not via sale or something. It is granted in exchange for military services and other obligations. The rationale
So
behind this is, yeah,
so I think that's why they have used this word tenants in chief because the property is not absolutely being transferred to these nobles, right?
yes,
Definitely.
that is also we will learn. So basically, the how long the tenants in chief, what sort of wide power they had, did they have any, limitations for use of the property? Can they sell the property without asking to king? In those days and all, they were not like, much thing that the other people used to do other than ask, without asking the king, they couldn't do. But later they did consider about, okay, have you been in this property for so long, and what is that limitation period that you need to cross in order to get the ownership of the property. And the word terminology like tenancy, that is not like a tenant that we know of, like rented person is not like person who is renting out the property is not the tenant. That is not to be misunderstood. Okay, here tenant means the person who is occupying, having the position. So terminology also, you have to, like, slightly change your mindset, because if we think from like what we already know, then we might get confused. So this is regarding the person who occupies the land and having the position, but that tenant may get the ownership later. We will see in the other chapters how he will get it, but these are now the origin and rationale of this particular property law. So this is how it all started, and this was when 1066, very very long back. Okay, and
Mhm.
the rationale behind this system was to create a structured society where land was held in exchange for service, thus ensuring loyalty and military support for the king. This structure was transplanted to Canada through. So this happened in where? UK, England, right? So
Mhm.
that same thing came to Canada, transplanted into Canada through the British colonization, and became the foundation of Canadian property law as well. Okay, so that's why we say reception of English law. Reception of
Mhm.
English law has been has been the foundation of Canadian property law as well. Then what about the forms? As like, what different forms of feudal tenures are there. So forms, especially free and common socage. So again, these are, new words that we are going to learn. Free and common socage. What are these? Feudal tenures were classified into various forms. So feudal tenures means that we saw of, this structure. So similar things, they are called as feudal tenures. The relationship between, different stages in the pyramid, phases in the pyramid, you can say. So the tenures were having various, classified into various forms. The most significant of Canadian property law being free and common socage. Free and common socage was a form of tenure that involved holding of the land in return for military services, often agricultural work or monetary rent. So there used to be different, exchange used to happen. Starting, it was for military, in return for, sorry, non-military services, often agricultural work or monetary rent. As we saw in the last picture of the pyramid that we, saw, right? It was what these people can do. Peasants can give food and services. They're not basically giving military services, right? So non-military services, and they used to give, do agriculture on the property, and they used to fulfill their duties. Now, and also sometimes monetary rent could come out of that. They used to pay. Kind of like, taxation system also developed from there. We will see that. So they were basically giving uh, groceries or food, you can say, in the earlier days. Then later, if they are not doing the agriculture, if they are carrying on some other business, then they have to, pay the money. Later, the money concept, whenever it was introduced, they switched to money in exchange, instead of doing some barter system, like, providing services, providing goods, whatever they are usually dealing with. It was a relatively stable and secure form of landholding compared to other feudal tenures like knight service or sergeantry. So basically, knight services and all were not really secure and stable, because in the structure, if you see, some, of course, not everybody will give that particular service, right? So this one was really convenient, and it was secure that either agricultural work or monetary rent was coming. Usually non-military services were getting. Now in Canada, free and common socage become the predominant form of land
Mhm.
tenure after decline of the after decline of the feudal system. So this
Vidya,
became, yeah.
sorry to interrupt you. Yeah, like they are using this terminology tenure. So
Mm.
usually matlab, what it signifies actually.
Mm. Tenure basically here means like um the property, the relationship, basically the rights that you have on the property.
Okay.
Hmm. Like tenure, like when you consider tenure, you would think of a time period, right? Time period.
Yeah, exactly.
Yeah.
Yes.
So time period is also associated with the rights you have with the property. For example, explain with a small example. I
Hmm.
have rented a property for 11
Hmm.
months. Okay,
Hmm.
11 months. So for 11 months, what I am in this property? I am a tenant,
Hmm.
right? So I am a tenant, recognized as tenant for 11 months only. So
Hmm.
these settings also used to happen, like you are doing agriculture work, you become the tenant of that particular property. You stay there, you enjoy the property. Okay, whatever goods, vagera, I mean, profit, vagera you're getting, you
Hmm.
enjoy it. Then you pay me this much, whatever we have already decided on. But they are, of course, not complete title. Okay, complete title requires it's a bundle of rights, land,
Hmm.
property rights. When we say property
Hmm.
ownership, when we say it's bundle of
Yeah.
rights, and
It's
it
bundle of
has,
rights. Yeah.
yeah, it's a bundle of rights, and it has lot many more things,
Hmm.
right? But those concepts will come under, fee simple, which we will see later. But now these, earlier stage, there was no like proper ownership as such, but there were these other forms of, yeah, tenure that people had. Tenure is basically kind of a temporary ownership that you have of a,
Hmm.
property, and that ownership will be very restricted. Like what rights you have on the property will be very limited and restricted.
Okay. So I was thinking like they are using this word in the context of the different, the rights in the property of a respective
Yeah.
person.
Yes, 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 exactly. So in Canada, free and common socage became the predominant form of land tenure after the decline of feudal system. It provides landholders with greater security and certainty as obligations were fixed and predictable. So, landholders landholders are the people actual owners of the property. Okay, they used to go under this particular system. They used to follow this free and common stockage basically, and out of that they could rent out, like kind of a renting out their property, right, for monetary rent or for non-military services like some goods or food, something like that they are getting, and that was giving them a greater security and certainty compared to other pyramid structure that we saw earlier. So we can see, earlier stage origin was this. We had feudal structure, then it becomes free and common socage. Then what happened? Incidents of tenure. So it's basically, slight changes you can see, and then we'll come to, at the end, we'll come to the current state. So incidents of tenure were on, yeah.
Sorry, Vidya, to interrupt you. So first we are talking about the feudal structure. So where we are talking about this king, then we are having this the persons,
Mm,
nobles, right? And
mm.
then knights, and then peasants, which we are talking about. And what about the other second form? So what was the change in that particular thing? These free and common sockage?
Yeah, so earlier there was a military service that was in exchange
Yeah.
they were getting now, but this
Okay.
became non-military services.
Okay.
Yeah.
So, like, if we talk about that pyramid, so can you show that pyramid once again?
In this, everything they have shown, because that is also feudal structure only, but
Uh-huh.
only this part remained, no?
Uh-huh.
Yeah, this part remained at the end. That is free and common sockage. You can say here,
Okay.
okay, this to get the land
Okay.
protection and everything. So free and
Uh-huh.
common sockage here. The remaining, you can say this
Okay.
was
So
the feudal
this was
structure in the
eliminated in
earlier
the second
stage.
form. Nobles.
Not exactly eliminated, but they were predominant means what? Like they were practiced more than these. They were still
Okay.
there, but they were practiced very less.
Okay.
By the time free and common socage came, these were practiced very less, and these were, very famous
Okay.
because they considered it as very secure part of secure land holding practice.
Mhm.
Okay. So we have the incidents of tenure. So what is the obligations? What are the incident of tenures? That is the obligations and rights of those from feudal relationship between lord and tenant. Now here, the concept of course, landlord and tenant, all these words came from here only. So we are going back. So slight understanding is slightly different, but these are like origin story, right? So this is how it all began. So lord and the tenant, okay, the basically landlord and the tenant, what are the rights and obligations involved? So the key incident word is here, you can highlight, or like you can give an arrow mark here saying the obligations and rights. Obligations and rights are called as incidents. Key incidents included homage and fealty. What is homage and fealty? Acts of loyalty and alliance to the Lord. So, first rights and liability in the feudal structure was regarding the loyalty. Once you are put in that particular land, whoever is the lord, you're loyal to them. You pledge your allegiance to that particular lord. Then second one was military services. The primary obligation in the feudal system, though it became less common over time, but it was still the military service. Relief, a payment made by an heir upon inheriting an estate. So that's called as relief. See, you can see the terminology sounds like something, but the meaning is completely different, right? So these things you need to understand and like just have an idea about it. They're not going to ask you what is relief, define it or something. But when that term is there in the question, you need to able to like decode it basically. That's the first task. Then we have another obligations and rights, wardship and marriage. The Lord's rights to control the estate and marriage of a minor heir. So that is also a particular, topic, that is wardship and marriage. Whether they have any, say in the wardship. Wardship is basically the child, minor, right? And marriage of a minor, they did have control over the estate and marriage of the minor also, whoever was a tenant that time. Escheat. What is the concept of escheat? This is also important. Escheat is reversion of land to the lord if tenant died without heirs. In case if tenant dies without heirs, then it reverted back to lord. That means if once a tenant is put up, he can use and enjoy the property, but not the absolute owner of the property. Otherwise, it wouldn't go back to the owner. I mean, landlord, right? It wouldn't go back. So it's the concept where, like, until and unless he's alive, he used to use it. Then, if he has kids, then it used to pass on. But if he doesn't have, it used to go back. So it's not very solid way of having a property law. So they obviously eventually changed, but those were the case over there. So the terminology here you need to understand is incident means obligations and rights. Then these incidents were gradually phased out or modified, especially as feudal system began to decline. Truncation and decay of the feudal structure. So, kabhi iska, like, the kind of, when did it all kind of seem to decline? The feudal structure began to decay due to several legal developments. There is this Quia Emptores. 1290, this statute, so this is a statute, this statute allowed tenants to sell or transfer their land without the lord's consent. So this statute came. See, earlier there used to be unwritten laws or like oral understanding between the lord and the tenant, whatever it is. But once a statute
Hmm.
comes, statutory law comes, then
So,
that is
hmm.
applicable.
So we can say that the common law, started predominated by the this statutes,
Yes,
right?
you can say
Hmm.
that.
Hmm.
So Quia Emptores, basically 1290. So this became a statute when this statute allowed, what did it allow? It allowed the tenants to sell or transfer their land without the lord's consent. So before that, before 1290, they needed the consent for doing that. Then effectively halting the creation of new subtenures and promoting a free alienability of land. Alienability means you can
Tra-
alienate the property, you can let go of the property basically, right?
Transfer, you can say alienability.
Hmm? Yeah, transfer, yes.
Transfers, yeah.
Yes, you can let go, you can leave the property, you can give it to somebody. So you can alienate from it. You can let go of the property by transferring it. So you can do that. You could do that instead of creating every time some subtenures. Like what used to happen was there was very difficulty in finding the title trace, right? So the person will again give it as subtenure to somebody else, somebody else. So finally, finding the true lord and getting the property properly transferred used to be very difficult. And effectively halting the creation of new subtenures and promoting the free alienability of land. It marked the beginning of the end of the rigid feudal hierarchy. So that changed with this particular statute. Then another statute we can see is Tenures Abolition Act 1660. This act abolished many feudal incidents in England. This is not a Canadian law, this is England law. So it happened there. Then, including night services, wardship, and marriage, transforming most tenures to free and common socage. Free and common socage, what happens? There basically they can, uh, provide non-food, I mean, non-military services, and they can enjoy the property. So that happened. Then this change was essential in simplifying land holding and making land ownership more secure and less burdensome. So that was the idea behind this statute, and that's how it applied. These reforms were mirrored in Canadian property law to a more modern system of land tenure. Then there's a, that was regarding origin. Okay, till now we were talking about origin. Now we are discussing about reception of English law. It's a very small concept. How did the English law came to Canada? The reception of English law in Canada occurred through colonization process. When British settlers arrived in Canada, they brought with them English common law and legal principles, including those relating to property. The reception was formalized through various statutes and proclamations, such as Royal Proclamation of 1763 and subsequent colonial laws. English property laws provided the fundamental legal framework for land ownership, transfer, and dispute resolution in Canada. This reception ensures continuity and stability in legal principles which were adapted to Canadian circumstances over time. So basically, reception of English law means it's how basically English law came to Canada and became applicable in every situation and how it all began. It began with Royal Proclamation of 1763. They had to set up some rules and principles, right? What needs to be followed here? It's all new country and new people, everything they needed to regulate it, everything. And then They needed to regulate and then make up this particular uh, system, legal system. So that needed reception of English law. Reception basically is receiving that particular English law. Then we have concept of overlay of English law on pre-existing Aboriginal rights. How did the Aboriginal rights get affected by the reception of English law? So we saw the feudal structure, we saw the reception of English law. Now, how basically this reception of English law is affecting the pre-existing Aboriginal rights? The imposition of English law on pre-existing Aboriginal property rights is critical and contentious aspect of Canadian property law. Before European colonization, Indigenous peoples in Canada had their own systems and land tenure and use. They had their own legal system, they had their own government, they were living by themselves happily, right? So, which were based on the communal ownership. So even today, we recognize the Aboriginal property rights, or like any Aboriginal rights for that matter, we recognize it as what? The government says it is a communal rights. It's a group thing. It's not an individual property right. A particular, chief of the, one particular land, First Nations will come, they will come and they will ask about the title and all, but it's not for himself, it is for his community he's asking. Okay, their property rights are also very different. Now then the overlay, um yeah, they had their own system. The Royal Proclamation of 1763 acknowledged Aboriginal title to the land and established formal treaties. So it is not just oral anymore, it has been written down. Now, however, the implementation of these principles was inconsistent and many indigenous land rights were ignored or overridden by colonial expansion and settlement. So because of the changes in the system, the law also took a backseat for a while, but they did emerge from this 1763 Royal Proclamation. This seems to be an important concept for them because that is the beginning, right? Beginning. So Royal Proclamation has acknowledged the Aboriginal title to the land and established protocols and land cessions requiring that land could only be ceded through crown. Land could only be ceded through crown through formal treaties.
So
That is
basically, it is talking about that the domination of English law on the pre-existing Aboriginal property rights, right?
right, right, correct.
Okay, okay. So this is similar to the concept which we have already studied in the foundation law, if I'm not wrong.
Yeah.
Okay, okay. So, from the exam perspective, to what extent it is, important? So we should focus on this thing because this we are talking about the feudal system history and how the statutes came into the force and they took over the common law, which was exist in existence before that. So, is it important to that extent, or just for a good to know thing?
No, no, it's just a good to know, like for
Okay.
understanding the overall concept of property law in Canada. To
Mm-hmm.
like it basically is, foundation for the entire syllabus.
Okay, got
Yeah,
it.
like a preview. The overlay of English property law often led to the disposition and marginalization of indigenous people. So this is now he's talking about real issues, right? What went wrong? And while some treaties were negotiated, many indigenous lands were taken without consent and adequate compensation, leading to ongoing legal and political disputes. So, because of such, like too early for changes, I would say, or too quick to get English law into Canadian property law, and merging that showed its difficulties in the beginning itself. Okay. Then in the recent decades, there has been growing recognition of indigenous land rights. However, in the current state, there are, legislations and like case laws. Basically, you can speak to indigenous Robin. Basically, um, indigenous people's rights. Okay, we can see the recognition of indigenous people's rights, and they were reflected through landmark cases such as Caldor versus British Columbia, R versus Curran, Delgamuv case. This we remember, Delgamuv case, and the Skilcoty Nation case. The first time where the recognition of title we can see, right? We can see first ever decision for title where it was granted by the court. These cases have affirmed the Aboriginal title exists and it is protected by Canadian Constitution. So all these cases are important for Aboriginal title, where they say that yes, this particular Aboriginal title has been existing and it is protected by Canadian Constitution, leading to a more complex and evolving legal landscape where indigenous and common law property rights coexist and interact with each other. So these things are basically here we are talking about the English law, reception of English law, and how the English law is connecting with the Aboriginal rights, right? So they are recognizing in the modern days, they are recognizing the indigenous land rights and titles in Canadian law. So the decision of Skilcoty Nation versus British Columbia, also one question could be asked, how the land rights are, decided in Skilcoty Nation decision by the Supreme Court of Canada, and or you can say how the English law reception affected in the understanding of Aboriginal rights. So this case of Skilcoty Nation versus British Columbia 2014 is a landmark decision by the Supreme Court of Canada that further clarified the nature and extent of the Aboriginal title. So nature and the extent of Aboriginal title, they were clarified in this particular case. How? Because they spoke about what is the nature and how basically the title will be proved. In order to prove, there was a test given under Delgamuv case, but it was applied first time properly, like successfully applied in Skilcoty Nation case. Basically, they said there are three things to be achieved. The European, prior contact, prior occupation, that is before the European contact, they had to be in that land. Then they had to show the continuity from that day to till date, whenever they're making the claim. And then there is third one is exclusivity. Okay. So these three things they needed to prove. And they successfully did also. And it's very difficult to prove. That's why there is there's no other successful cases yet after 2014. Now it's been 10 more years. There are no other cases. Okay. Then we have the decision established several important principles. So basically why this particular case law is important, we can read this. Nature of the Aboriginal title. Aboriginal title confers the right to use and control the land and enjoy its benefits. The title is a collective right and held by the community, and it is sui generis, that is unique. Okay. So this particular Aboriginal title, we are talking about Aboriginal title, not just any title. So it is a communal thing. It's not an individual right. Land use and development. While Aboriginal title includes the right to determine how the land is used, is the right not to right is not absolute. This right is not absolute. So the Aboriginal title include the right to determine how the land is used, but still it is not absolute. How can you say it is not absolute? Because the Crown's fiduciary duty is there, no? That will come
Hmm.
into place here. The government
Hmm.
can infringe on Aboriginal title if it meets the justification test. And do you know which case or which test it is? Uh,
Harvey Sparrow.
Yes, R versus Sparrow. So Sparrow test is there, which basically proves that Aboriginal rights also is not absolute. Basically, nothing is absolute. In
Hmm.
charter rights, we have
Yeah,
what is the
Oaks
test?
test. Oaks test.
Yes, yes, Oaks test. So similarly, for Aboriginal rights, we have Sparrow test. Very good. You have completed constitutional law, I think then.
Yeah. So
Mm.
I have given all the exams. So this is my
Last
sixth.
exam.
Yeah.
Great, great, great. Then we have further explanation on the importance of skill coordination decision. The skill coordination decision has profound implications for resource development, land use planning, and the reconciliation process between the indigenous peoples and the Canadian state. It underscores the necessity of negotiating and accommodating indigenous land rights in the developments on the traditional territories. Therefore, the sources of Canadian property law are deeply rooted in the historical and legal traditions. The feudal structure doctrine, that's where it all started, feudal structure doctrine. Then what happened? Free and common socage, the reception of law, reception of English law. Then uh, then currently like the modified version of the reception of English law is available, right? Based on the checks and applications. So this is where we kind of stop today. I don't want to put too much information in the first day. And I'm also slowly sharing the notes as well. Take a printout of those.
Hmm.
And we are done with the first part of the syllabus. If you see in the syllabus, just
Hmm.
mark from here as well, okay? As in when we are done, mark in here. So we understood the sources of Canadian property
Hmm.
law, origin and rationale forms,
Hmm.
incidents of tenure. Then we saw these statutes and reception of English law, overlay we did. Okay, so the
Yeah.
basically this portion we have completed.
Okay.
Then the remaining chapter we have regarding the division of basic divisions in the law of property. It is, in simple, it is basically dealing with what and all types of properties are there: real
Okay.
property and property that is called as personal chattels. Personal property is called as personal chattels. And there are some more words
Hmm.
that we will discuss tomorrow. And before we go, I'd like to also show you the question and answer that I've shared with you guys. Okay, all chapter question and answers are here. We have questions on first chapter. Okay, first
Hmm.
chapter. Now we have understood certain topic, right? Let me see what topic we have covered. On that only we'll see. These are all later concepts. We have not yet done. Beneficial. So some will be, very small fact pattern questions. You can see what happens when a property owner creates a trust, naming their children as beneficiaries and a close friend as a trustee. The trust proper to specify that children will have beneficial rights to the property upon reaching a certain age. However, the trustee mismanages the trust and uses the property for personal gain. Can the children take legal action to enforce their beneficial rights and remove the trustee? This is we are not covered this, but I just read this
Mhm.
question to give you an understanding of what sort of questions are covered in the on these question answers
Okay.
booklet, and terminology, everything is there. So for answer writing, basically theory questions, right? Theory questions or fact pattern questions also, we need to have a particular format for the answer. Same thing that I used to say for foundation, same thing we will use. Introduction and meaning,
Mhm.
historical context, if it is available, of course. Okay, for some
Mhm.
concepts, historical concept will be there. Sometimes it's not there, don't write. But introduction and meaning should go hand in hand in the first paragraph. Then you will write about the content, like basically what they have asked in the question. If they asked about worthier title, doctrine of
Mhm.
worthier title, write side heading doctrine of worthier title. Explain what it is. Then you say, what is the specific answer? Like, did they ask you types? Did they ask you to solve a question in the fact pattern way? So that you do in the body of your answer. Then before you write the conclusion, few lines about your opinion. Okay, post your opinion as well based on the syllabus material, what you understood. What do you think should be done over there? As a lawyer, as a property lawyer, you will be writing your opinion over there, 2 3 lines. You don't have to put side heading like this is opinion, but that you can just mention. Then the final conclusion portion will be there. So this is the format of your answer for property law
Mhm.
question. And yeah, just keep that in mind. And slowly I will be sending 2 chapters or something, so that you can take a printout and make the booklet. These question and answers you can keep along with the chapters, or separately also you can make a file. That's totally your choice. And the notes from the text materials we have taken, and I have seen different materials from the different mentors. Basically, the question answers were very poor. They were not covering what was supposed to be covered. And after writing the exam, I really felt like, thank God I didn't refer certain materials which were available to me earlier. And I chose not to. While reading
Mhm.
only, I didn't understand like head to tail. So, and my way of preparation was, whenever it's theory and all, I need to write it down. So, as we have online exam, I type it. So that's how this question and answers also started. I started preparing that, and that was my preparation for exam. That's it. And
Mhm.
I wrote the exam, I cleared it. So now also I'm saying, just have a complete clarity of each concept. This first chapter that we did today is very, very basic. So not really important for the exam context, but for the understanding, we need it.
Mhm. And one more thing, how many questions we are having for the entire syllabus? Practice questions.
Basically, I have tried as many as possible. I have not counted
Okay.
overall questions. It's
But
basically
okay,
chapter wise.
but we are having the question answers for the each and every chapter, right?
Each and every chapter. Yeah, you can see here.
Okay.
Yeah, see all 11 chapters.
Okay. Okay. Right. Thank you.
Okay, these are theory questions and like chapter specific questions. But आपको
Mm-hmm.
एक I am also planning additionally at least 3 sample papers. Three
Okay.
sample papers in the sense exam type. This is chapter wise, no, but exam में आपको chapter wise नहीं आएगा. You will not get chapter wise.
Mm-hmm.
So you need
Obviously.
to also see 2 3 papers, question papers, where
Mm-hmm.
you get questions from different chapters. Sometimes one question will be dealing with different topics. So you need to
Okay.
have that practice as well. So in the remaining, after the syllabus is completed, we will be practicing on question and answers. No, we'll discuss on
Mhm.
those papers, and you will be writing answers for those 3 papers.
Okay.
and I will correct it, and you'll have a better understanding of how to write, how much to write, and whether you're able to apply the concepts or not. So you'll be having
Mm-hmm.
enough time. Don't worry about property law. This is easier subject, but just
Okay.
that clarity is needed. That's all.
Fine.
Okay.
Oh,
So thank you for joining today's class.
thank
And
you.
Thank you, Vidya.
yeah, I think we are off to a great start for
I
property.
just